You're never ready. I'm hungry. I'm as ready as I'll be. When you come here, I'll come. Sir? I wanna, you know, try to get scared. Yeah. I'm not 37. I mean, that's not, okay, number 8. He wants the corrections. He wants. He's a funny guy. Okay. He's the one. Why are you here? Jail? No, I know, but you should be over there, bending around if I give her a bottle. Oh, no. All right. All right. See, I haven't done this one. Tomorrow I'll be
recording in progress.
So the question says ask for these. They start on page. All right, they still state? Yes. They start actually 136 now. You want to tell the PD? I don't care. Look at that. Okay.
How long has it been since you were blind?
Oh my God. No, actually I was here 2 years ago. But I haven't been good since 2000. Good afternoon, everybody. All rise and raise your right hand, please.
De pie, levante la mano derecha.
Do you swear that
Get this, I lost that. Breakdown.
the truth and nothing but the truth? If so, say I do.
Where did you find that? On your, just over there. Yeah.
Juran decir la verdad, toda la verdad, nada más que la verdad.
You may be seated. All right, it's a PD no, but Mr. PD. Mr. PD, we're going to start on page 13 with number 36 and we'll continue from there on.
Got it. He's here.
Right. Oh, can you announce your name? I'm sorry. Jesse. No. Sir PD, can you announce your name, please?
Andrew Black, Public Defender. Good morning.
Good morning. We still putting the public defender on all these cases?
Accept form.
All right. Jackson, Gary. Is that you, sir? Yes. So you're charged with the battery of police officer. I always want to say, I plead.
Yes, sir.
It's an added charge.
What another he's but he's an added charge to the ones that he's only there for. Okay, sure. Okay, what do you want?
He's already being held, Judge, then we would stipulate to a $1 bond if he's being held on another case.
Madam Clerk, what do you want me to
Right here.
do? Yes, Erica. Okay. All right, dollar bond.
He's being held, Judge?
That's apparently he's being held on.
He's already in custody, added charges.
Is he so he's being held on the other charges?
Is he being held no bond on the other charges?
He's in custody.
Okay, thank you. Thank you.
Okay, you understand it? All right, Figueredo, Valdez, Gismel.
Defender refused court. Reset for tomorrow.
Reset for tomorrow. Do I do that in the same place or somewhere else?
I believe there was a victim for Figueredo on Zoom. Whoever is here for Figueredo, this case was reset for tomorrow. You can log back on tomorrow. Thank you.
Smith, Aaron, Ward D.
Reset Wardy.
There you go. It's yours. Hope everybody gets reset. No?
Judge, for Mr. Smith, we can waive presence.
Okay. Yeah. Want to do it now?
Yes, please.
Date?
We are asking in this case, Judge, for a standard bond, although he does have drug priors from 2018, they are withheld. The standard bond in this case is $2,500.
Judge, it seems he has a permanent address. He only has drug priors. This is for personal use. We'd be asking for pretrial services with an alt bond.
Objection?
The pretrial services, no objection.
Alternate bond.
Thank you.
I didn't get the bond, Judge. Sorry.
Alternate bond 2,500. What do I write? Do I have to write it? Do I have to write PDS?
And Judge, unless you state otherwise, we'll be finding PD or PC in these cases.
I'm sorry. Yes.
And it was already.
You haven't protested yet.
Oh, okay, understood.
Placid, Dimitri.
Reset report.
Fun. Grant Rogers, Larry. Is he there?
Yes, 1 minute.
Okay. He's got another change.
Circle. I like to write in here, like ask me. That's what you want.
Mr. Grant Rogers, we charged with battery. You know, it's an added charge. State,
Judge, he's being held on the other case then?
yes.
Okay, then we would stipulate to a $1 bond.
$1 bond. Of course, PC. These two. These persons. It's confidential. What that means. All right. All right. We're going back on the breaking calendar.
Judge Corrections wants to call number 8. It's
Number 8.
page, bottom of page 3. She has a private attorney.
That's the. Yeah. Well, she doesn't have an attorney here. She has a bondsman.
Okay,
Is this Artigas?
No, Price.
Thank you.
We haven't charged grand theft vehicle.
Yes, Judge, we are actually asking for pretrial detention in this case.
Yes, lost your 10%. Yes, lost your 10%.
Judge, what is-
I'm talking to him. You're asking for PTS.
Judge.
Oh, pretrial detention. I'm sorry. I misunderstood you. Yeah.
Handing you the proposed order now, Judge.
PD?
Judge, this is not a crime that qualifies for pretrial detention. A crime being in F1 is not something that makes it eligible for being held no bond. It's either a PBL or it's one of the.
I don't know the acronyms.
So, Judge.
It's either a punishable by life felony or it's one of the.
It's a dangerous crime.
Or one of the offenses listed under subsection 5 of 907.041. I'm looking at that list right now. I do not see grand theft on that list. Whatever the case, if this were eligible for pretrial detention, based on the fact that it's only an F1, it's not properly charged as an F1. So I'd like to be heard on that matter as well.
Judge, it is charged as an F1. It's charged as a grand theft of a vehicle. If we're looking and handing you the.
I can't hear you, Judge.
Hold on.
Counsel, can you hear me?
Yes.
It is charged as a grand theft, first degree felony, and that qualifies under subsection 1 of the statute. Additionally, the defendant in this case is on probation until next year of January 8th for criminal trespass in Georgia. This is a first degree felony, so she qualifies for pretrial detention.
Judge, that's not the way pretrial detention works. It's either a punishable by life felony or it is one of the enumerated offenses under subsection 5 of 907.041. I don't see theft under that list. Whatever the case, there is not probable cause for first-degree felony under the statute. The theft
Now, how does a probation from Georgia qualify her as a pretrial detention?
So Judge, I was just providing that information before. However, my argument was under pretrial detention statute, which if we look at subsection 1, it states that the offense is one for which it's a capital felony, a life felony, or a felony of the first degree. That's an or, not an and. So it is a felony of the first degree under the statute if it qualifies.
Judge, how about we go ahead and talk about the fact that it's not properly charged?
Right.
It's under the.
Let me read the A4.
Okay. So, Judge, I've been advised that if it qualifies under subsection 1, then it's sufficient. Counsel, is your argument that it has to meet all the elements under the pretrial detention statute?
Please.
Oh, see, I think he's challenging PC in the case.
Okay, now he.
And counsel, if you could give me the subsection under which you're saying that this qualifies, I'd appreciate it. And the statute number, please.
Yes, so what argument is under statute 907.041 5D. We look under subsection 1, it's presently charged as a first degree felony.
Subsection 1 is legislative intent.
Right, and that's what we're arguing under, that it allows it. Is your argument that it requires all 4?
I'm reading subsection 1, legislative intent, and I don't see anything about first degree felonies qualifying for pretrial detention.
Judge,
Is it another subsection?
it's okay, Judge. In terms of the pretrial detention motion, I was speaking to Sir Clerk here, and he's stating to me that usually has to qualify all of the subsections. So because of that, in good faith, I will withdraw the motion. However, Judge, I am asking for an elevated bond. And
All right, I'm going to find probable cause. Give me your.
It's a probable cause.
Yeah, I'm going to find probable cause.
Judge, can I be heard?
Yeah, you heard.
So the theft statute, you look at the theft statute, 2C6 describes thefts of vehicles as third degree felonies. For it to qualify as a first degree felony, it would have to be over $100,000. And that's not even alleged. It's alleged to be a vehicle under 2C6. That's a third degree felony. Now, as to simply just theft, I don't see any factual allegations that she knowingly and unlawfully obtained this vehicle or that she intended to deprive it from its owner. This A form is confusing. It says that she's on a lease agreement. I think the allegations here establish that it sounds like she thought she was in a leased vehicle. She's visiting from out of town. That would make perfect sense. So I would argue there's no PC for theft at all. And if there is, it's a third degree felony under 2C6.
Judge, it does state that it's a white Nissan with dark tinted windows. I understand that counsel's argument is that it has to state the actual amount under the statute, under the charge. I am looking that up, Judge. If that is going to be the argument, we would ask to reset it for tomorrow for the officers to appear for a PC.
Except for more.
One moment. Judge, if you're finding PC for a third degree felony under the statute, she can afford bond, and we prefer to move forward in that way instead of keeping her here.
No. I'm going to set for more.
Judge, I just want to let you know that in order for anything the officer says to make any difference at a pretrial or probable cause hearing, he would have had to know that the vehicle was worth more than $100,000. There can be no additional research in order to prove that. There can be no Googling before the pretrial, before the probable cause hearing. I don't know how he's going to establish probable cause.
I don't either. Tomorrow. Thank you, Your Honor. Appreciate it. I'll see you tomorrow. Schofield, Tina.
Reset medical judge.
Mark. Fabiola.
Judge, on Ms. Price, what is the bond that you would set if you found PC for a first degree felony?
Asking you. You able to set it?
And how much, I didn't hear, how much would that be?
7,500.
Okay, Judge.
7,500.
No reset.
No reset. No, 7,500.
Okay, so are we still doing a PC hearing or no?
No, PC's found. Mark, Viola Mark.
What number, Mr. Mark? Oh.
Judge, we are asking for,
Not there. Okay.
thank you. For Fabiola Mark, we are asking for an elevated bond of 1,500 instead of the regular 1,000, given that although she doesn't have convictions, she has 2 prior arrests for battery that are recent.
All right. Ma'am, you're charged with battery of police officer. Or if I probable cause, it'll be 1,000.
Judge, hold on a second, one moment, okay? Can I be heard as to the bond?
Sure.
So, Your Honor, the course of being Baker acted here, I think that calls into question the mental culpability underlying offenses. I'm not arguing PC, but if you allowed her to have GPS, alt bond, or PTS, alt bond, if Agape was willing to take her back, she could go back to Agape.
Okay. 1,000 bond. Ashley.
You said 1,000.
Yes.
Your Honor, I just got custody of my kids. Their birthday this month. I don't have $1,000.
Yes, ma'am. $1,000 bond.
Sorry, yeah.
But Miss Ashley, these are added charges.
For Ashley Sanchez, we are asking for felony hold. She has 2 open.
$1 bond. Felony hold.
Judge, she's already, these are added charges. There's no.
Yeah, I know. Yes. How many does she have?
What is it, Miss Sanchez?
$1 per count. $1 each count. Only. We can afford that. Patterson, one second. Hold on. Go ahead. Matthew. Or Nora.
We are asking for an elevated bond in this case. The defendant has 2 prior battery withholds as well as a disorderly intoxication guilty prior.
So you're charged with the battery. We'll find public cause. And it'll be, what's the standard bond?
Standard bond is 1,000. We're asking for a $2,000 bond in this case.
$1,000.
I'm sorry, Judge, would you be?
1,000. Does he have more than one? No, I forgot. We're together.
He has 2 prior batteries with.
I know that's was the 2 actual ones over there. Ricardo, Suses, Ricardo.
No, that's not her, Judge. This is
Who's she?
this is number 6, Mr. Pass.
Oh, it's reset for medical.
Ramon. And felony hold.
And the case number is F190927996.
Artigas. Regla.
What did you get, Miss Douglas?
Bond.
He's on felony hold.
$1 bond with the hold.
Now, Judge, Miss Artigas Soto will need the service of the interpreter.
$1 Madam Interpreter, you there?
The
Madam
interpreter is
Interpreter?
present, Your Honor.
Okay. Man in charge with possession of controlled substance, possession of 2 counts, and drug paraphernalia 1 count.
Tiene 2 acusaciones por sustancias controladas y una por parafernalia, o sea, instrumento para utilizar drogas.
Apparently, she's not on bond in a felony charge. Correct? I'll be a felony hold. And 1 double each count. Shamika Johnson.
Ms. Johnson is a bond out.
It's a bond out.
Right. Reynolds, Michael,
We don't have him.
Reset warning.
reset.
What was the last?
Roderick,
Yes, Your Honor, we are. Oh, let's wait for that.
Got mobility issues, got 8.
Okay.
Mr. Holt, you've been charged with possession of cocaine, possession of crystal meth, and tampering with physical evidence.
Your Honor, we'll be asking for elevated bond of 5,000 in each count. He has 86 priors, 6 of them being from 2025.
Judge, I have a PC argument as to count 3.
Say that again?
I have a PC argument as to count 3.
All right.
Count 3 is tampering. This is not tampering with physical evidence. He's not concealing or destroying the evidence. He puts it in one hand, he puts it in the other, he sets it on the ground in front of the officer. That's the opposite of concealing or destroying. That's making it apparent to the officer. Now, had he swallowed it, had he tossed it into a storm drain, had he tried to flush it, that'd be a different thing. That's the top of page 2 where it describes tampering.
Date.
Un second, Your Honor. Your Honor, the defendant was moving from one hand to another, concealing the item while the officers were doing the investigation.
No PC, count 3. $5,000 bond, 1 and count. $5,000 bond and count 2. Found PC on the other 2 counts.
I didn't. Can you repeat the bonds?
Count 1, 5,000. Count 2, 5,000. And is count 3 to be released outright because you found no PC on?
Yes.
Release outright.
Somebody's gonna tell me, somebody's gonna have to explain it to me. What the policy of the clerk's office is, because I think it's a policy of the clerk's office. Well, from whom? This doesn't make any sense. Yeah, it's-
Okay.
well, but I got it. All right. Winter, Melange,
So, Judge, the corrections is resetting.
we said Ruiz.
Hello, Judge.
I'm sorry, Judge. As to number 13, I'm going to go ahead and waive his presence.
Escalante.
Yeah. You can step out here.
I can't, she's not here, I can't issue, I can't read the stay away order,
Okay,
so I
Under-
reset tomorrow.
okay.
Ruiz. You speak English?
He does, Judge.
Right. So you're charged with, robbery, son snatching? What's standard bond?
Your Honor, it's to be said,
To be
but
reset?
to be said,
Oh, the bond, to be said.
It's to be set by you.
no, to be said, Your Honor, to
Well,
be said.
oh, I understand. So there's no standard bond.
There is not.
The PD and the state attorney is not agree on standard.
So, Judge, in these cases, when it's to be set, what I ask, unless there are other arguments, is that you set the standard for whatever it is, the third degree. So in this case, I would ask for a $2,500.
Well, if it's to be set and nobody gets the argument, it's standard bond.
Yes, sir. That's my point, sir.
Your Honor, for F3, it's going to be
What is it?
2,500.
All right.
Your Honor,
Standard bond.
but we are asking for elevated bond and for GPS
That's not what
because
you said. You said to be set.
yes, Your Honor. We are asking for elevated bond of 5,000, Your Honor, and for the defendant to have GPS. He has 1, 2, 3, 4, 5, 6, 7 cases related to DV, and this one is a DV case.
He's going through his whole family, apparently.
This one, the victim is going to be
Have you,
his ex-girlfriend.
Judge?
All right, tell me.
I would only just point out that if you look at the A form, that these are 2.5-year-old allegations. I don't think that there are allegations over the course of the past 2 years, and so I don't think a GPS or an elevated bond would be necessary in this case. Asking for standard.
That's a GPS, keep him from committing domestic violence.
Your Honor, yeah, we track the defendant's actions and we cannot see what he's doing, but we have at least like a pattern of where he is.
Is that what?
Yes, Your Honor, he has sexual cases in the past.
Did I hear that before? And it was 2,500 with the GPS. I don't know.
I'm sorry. So that was 2,500 with GPS.
Yes.
Okay. You're gonna have.
What's it? So tell me what.
Level 1 is going to be full, like lockdown. House level 2 is he has permission to go and work and stuff like that, and level 3 he has roaming.
Does
So
he have a job?
he just is being tracked.
Does he?
Judge, he does have a job. We're asking for just the standard bond, Judge.
No, I understand. The question is, does he have a job? What does he do?
He does job. He works at a law firm.
You work for a law firm?
Yes, sir, I have a JD.
You look familiar.
Probably, I do bankruptcy law.
No, I don't do that.
Your Honor, we will be asking for level 1 and
I'll give him level 2. 2,500 bucks. PC.
2,500 plus GPS?
Yes. Yes. And a stable order from Claudia Galdo. What's wrong with your work for, sir?
Claudia Aldo is my fiance.
Bianchi?
And she's ready to file an affidavit of non-prosecution.
All right.
It's been 2.5 years.
Okay. All right. Horace Washington. Mr. Washington, you're charged with battery, aggravated battery.
I have PC argument, Judge, when you're ready.
All right, go ahead.
So Judge, what makes a battery aggravated is if there are injuries that result in disfigurement or there is a deadly weapon used. In this case, the allegation is that it is a stick and there's no injuries noted. I think there needs to be more in order for there to be PC for an aggravated battery opposed to an M1.
State.
One second, Your Honor. Your Honor, what it appeared, he definitely grabbed a stick and is Wait.
Describe the stick, number one.
we can reset it for PC argument tomorrow.
No.
We can-
It's not gonna happen. I gotta do this. What's the standard bond on aggravated battery? Did anybody actions?
It's an F2 judge, so it
5,000.
would be 5,000. But I'd be asking for PTS judge. He has an address to go to. He's got surgeries coming up in the next few days. He has cancer. He's surgery on.
Judge, Your Honor, a stick can definitely be a weapon. Aggravated battery just requires.
I did. I'm gonna find PC.
Okay.
So this one, what's the bond? PTS. What is that? I'm sorry. What is it? Okay.
I'm sorry, I didn't hear that.
Since he doesn't qualify. So it'll be $25 bond. Is there a stowaway order?
Judge, he's not going to be able to afford that. He's got cancer treatments that he's going to need in the next few days. He's got surgery scheduled. I don't see a long history of priors here. He's not a danger. There's no allegation that he's a continuing threat to the community.
What's this? Oh. All right. So you have to stay away from Daniel Minutes, my ruling stands.
I'm sorry, that was 2,500 or 5,000.
2,500. I think I put the ruling down. Which one's this? What? This was Luis? There was a missing minutes. Okay. So this is Washington, right? That was Mr.
Yeah, the case we just had was Mr. Washington, Judge.
Okay, I just want to make sure.
Mr. Dorfield is the bond out.
Okay. You said Dorville? It's a bond out?
Bond out. Judge.
Lemus. Jusnier. Lemos.
He'll need an interpreter, Judge.
Interpreter present.
So you're charging the control substance.
Señor, la acusación es por el tener posesión de sustancias controladas.
I'm gonna find probable cause. What's being done?
2,500, Your Honor.
25. 25.
$2,500 de fianza.
Carl.
Three separate PC argument today. We're waiting for the officers to log on to the Zoom. Could we pass it?
They're
Better hurry.
They're passing. Yeah.
Officer Gonzalez? He's on the platform, Judge. Officer Gonzalez?
Yeah, he's up.
Officer Gonzalez, can you mute yourself?
Yes.
Are you here for the case of Whipple Carlton?
No, I'm here for the case of Eric Pavon Montoya.
Okay, we could briefly pass. We're waiting.
Let me ask you. See, if he's not on the camera, how do I know he's the officer? Good idea.
So, Judge, before we pass Mr. Whipple, can I just speak to him about possibly bonding out so we don't have to go through the PC hearing? You can't? Never mind.
Go ahead.
Come on. I'm sorry, Judge. We can go ahead and pass.
Okay, fast. Roberts, Carlos, I'm sorry, Carlos Roberto Mirinla, I think. Is that him?
Yes, and I'll need an interpreter.
So you're charged
Interpreter present.
and robbery. I'm gonna find probable cause. What's the standard bond?
Your Honor, he's being held no bond in AC for case F
Okay.
17-13-119. So we can ask for standard bond 1,000 in the battery and 2,500 in the robbery.
Señor, usted tiene una detención.
Only if I have to count one. No, two.
Son 2.500 por la acusación 1.
And you can stay away from Francia Blanca.
Delcia Vega.
You have to, he's already on no bond. All right. Oh, felony hold.
Okay. Tiene 2
And stay
detenciones
away
por
from
delitos mayores.
Francia González.
Francia
Stay away
González.
from her.
Tiene que mantenerse alejado de la presunta víctima.
Okay. Lamont Moore.
He's out on felony F25-15908.
So you're charged with battery. Aggravated.
Yes, so Judge, we are asking for an elevated bond actually for the open felony that he has. He's on the deferred prosecution program. So he's in the pretrial diversion program for the open felony that he has.
Does he have an open bond on that?
We would be asking for a felony hold given that it is an open felony, Judge.
The felony hold. What are you asking for this case?
We're asking for we would stipulate to a $1 bond on this case
No.
in exchange for the felony hold. Thank you. And we gave you a stay away order, Judge, if we could please advise.
Yes, so you will stay away from Shea Brown. No drugs, no guns, no criminal
Repeat it, please.
endeavors.
He's just warning you that you have to stay away. It's a stay away order from the alleged victims in this case. Do you understand?
Okay, yeah, she that. All right, Carlos Crespo. He's on a felony.
That is correct, Your Honor.
So we're impose a felony hold. No. Should I?
I'm sorry, Your Honor.
I used to do this a while back. I'll revoke bond. Revoke bond. It's got no bond. No. Felony hold. PC. What's the charges? Possession of controlled substance. Meth. What's the standard bond? You want $1 or you want a standard bond?
Requesting dollar bond.
We can stipulate to $1.
$1 bond. Joel Cortez.
Yes, Judge, we are asking for an elevated bond. He has a guilty for battery and a guilty for burglary.
So you're charged with possession of firearm by convicted felon and a concealed firearm.
We're asking for 2,000 on the last count and 5,000 on the first 3 counts, Judge.
We're requesting standard bond. Judge.
Understand. PC. You want to repeat this again? What I want to do?
Yes, Judge.
Don't want to count for what?
He has 2 different cases before Your Honor.
He does.
Are we addressing the one ending in?
We're addressing the one that has 2 counts.
Okay.
The concealed firearm and the firearm.
Yes, Judge. On that one, we're asking for an elevated bond. He has a prior battery, guilty.
He's only got 2 counts on that.
Yes, Judge.
And
And he has a burglary guilty from 2018.
what's the bond that you're requesting?
For this one, we are requesting an elevated bond of 7,000. I'm sorry, yes, 7,000 on each, Judge.
On each count?
Yes, Judge.
$5,000 each count. No, 362. No, that's I'm sorry. Yes, 6.
66?
68. And case ending in 6-6. This is count from, I don't know what this is. Possession farm. Yes, two counts of those.
He
What?
has two counts of those.
Why this is two forms?
So Judge, that was the one that we were asking for an elevated bond of 7,000 on. That's the one where the standard is 5,000.
Okay.
Requesting standard bond on the
PC 5,000. 5,000. Count one. Leticia. Diaz. So you're charged with stolen property, dealing with stolen property, and something about a pawnbroker. False. We'll find probable cause. What's the standard bond in accounts?
Judge, if I could just have one, just talk to him about bond.
Okay.
Judge, we're requesting standard bond.
What's standard
This
bond?
they will stipulate to
What's the standard bond?
250,
In each
2,500.
$2,500 in each count.
Okay, to be.
José Luis Requena. I'm not sure who wrote this.
Bond out.
Found out.
Better.
Pierre or Marquis Pierre. So you're charged with domestic violence, battery, 2 counts. We'll find probable cause. What's the standard on these two?
For the F3 is going to be 5,000.
F3 is 2,500 now.
Oh, thank you.
Each count?
And M1 is going to be 1,000.
So 2,500 count one, 1,000 count two.
Yes.
They're both strangulation. I missed that. All right. I'm sorry. Can you repeat that? $2,500? Okay.
Yes, yeah.
Good. And sir, you stay away from Caroline Pierre, at least for her fee. You're not to engage in criminal activity, possess firearms or illegal drugs, and also no weapons.
No contact, no weapons, no drugs. Do you understand? Okay.
Marquez Barrera. We had him on misdemeanors. We get interested in the misdemeanors in this case. I thought we had him in the misdemeanor calendar. No? Somebody else. Thought we did. All right, so you're charged with assault, aggravated assault, you're charged with disorderly conduct, you're charged with 2 resisting arrest, and
I'm sorry, Judge. He's going to need an interpreter.
okay.
Interpret present.
All right. So you're charged. Do you have a warrant? An outstanding warrant?
Yes, so he had multiple outstanding warrants, one in a misdemeanor case and another one in a traffic case misdemeanor.
Tiene múltiples órdenes de arresto en delitos
The
menores y
misdemeanor
mayores.
case, the warrant amount that the judge said was 10,000. And on the traffic case, the misdemeanor bond that the judge said was 500.
Where do I write that?
We would ask you to keep that amount of bond, Judge.
Yeah, but I have to write it. Which? No? I don't have to write it. What'd you say?
It's already set.
It's already set?
Yes, that one's already said, Judge.
Okay, then that's,
And then for this case, we're asking for an elevated bond, given that the defendant has those open cases, Judge. And the open case that he has, the misdemeanor, is actually an aggravated assault that was bound down to felonies, so now it's a misdemeanor. It's still the same nature of the charge with which he's charged for here.
Requesting standard bond, Judge. He's got $10,000 on the bench warrant.
PC, what, elevated request,
Asking for 7,000 instead of the 5,000 standard bond, Judge.
standard bond. Each count or which counts are those?
Aggravated deadly weapon, we're asking for 7,000 and standard bond on the rest.
So count 2 and count 3, 5,000. Is that what it is?
So, sorry,
Right.
Count 2 and 3, standard
150
bond.
each would be the standard for those, Judge.
What, 150?
Yes. And on the felony
Got it.
aggravated assault, we're asking for the 7,000.
Yeah, 5,000 on the count. And I'm sorry, stay away from Allen and Urao and Ramsey Persaint.
Señor, tiene que mantenerse alejado de las supuestas víctimas en este caso. What was the total amount, Your Honor? I couldn't hear the state.
5,000.
10,000.
5,300.
Okay. So 10,000 y 5,300.
Marvin Edwards.
I'm sorry, Judge. The interpreter's going to have to repeat that. We're having a really hard time hearing her on our end.
10,000.
If you could just repeat the stay away order and the bond amount.
The stay away. El señor tiene que mantenerse alejado de las presuntas víctimas en este caso, en estos casos.
Judge, he also got the immigration hold.
Well,
I need to write it. Yeah, I need to write it. So you also have the immigration hold case. What did I guess? All right. Marvin.
I'm sorry, just for the interpreter, we're having a really hard time hearing the interpreter. Can the interpreter repeat that this defendant has an assault?
Okay, you're gonna the state is gonna have to repeat it now because it's been a while.
What do
And if you can project in the microphone because I cannot hear. I'm sorry, I cannot hear the state when she talks.
What do you need me to repeat, interpreter?
I'm sorry.
What do you need for us to repeat?
The defense is asking for the results.
Can I have those documents back? Mr. Clerk. All right. So you just stay away from Ramsey Croissant and Alan Tangurao.
Señor, tiene que mantenerse alejado de Ramsey Person y Allen Rumau. Tiene que mantenerse alejado de esas personas.
You have an immigration hold.
Tiene una detención de inmigración.
And count 1, the bond is 5,000.
Una de las una de las fianzas son $5,000.
And count 2 and count 3 are $150 each. Total of $5,300.
Y las 2 y la 3 son $150 cada uno, o sea que un total de 5,300.
To stay away from the skirts where?
The one that's located 1330 Southwest 8th Street.
13320 Southwest 8th Street. The skirts, so stay away from it.
Tiene que mantenerse alejado del 1320 Southwest de la 8 calle.
All right. We'll move on now to Marvin Alvarez.
We can't hear. Judge, we can't hear the interpreter.
So there's nothing I can do about it. Next.
Is there some way we get this louder or something? Is there?
That has been the trouble with this all week long. The audio has been very off.
Sir, you're charged with petty theft to
Interpreter,
conviction.
he'll need. Sorry, Judge.
No problem. What's the standard bond?
You heard us to PC, please? In order for it to be a felony, there has to be an allegation in the four corners of the A form that it's got 2 prior convictions. There's no such allegation. It can only be charged to them 1 at most.
The state will be asking to found PC in the misdemeanor crime.
What's the standard? I'm fine PC. Misdemeanor. What's the bond?
I'm sorry, Your Honor?
What's the bond?
It's going to be an M1, so the state will be asking for 1,000.
Is that the standard bond?
No,
What's the standard bond?
I think it's 500.
500 bond. Bond.
Yeah.
And you to stay away from Navarro Discounts Pharmacy at 1601 West Flanders.
Dice que me vaya de ahí.
Yes.
Oh,
Stay away.
okay, thank you.
Okay.
Me voy a la casa.
500.
Me voy a la casa.
I don't know what you're saying. I'm sorry.
LeBron Cáceres. I know we did this one.
He refused court. We said for tomorrow.
We said more.
Judge, we can waive his presence.
Well, we had him. What do we do? In this case? Yes. Oh, he was there because I know his name. I wouldn't forget LeBron Cáceres.
Yeah, and I don't think if we had a misdemeanor we addressed it, maybe he also refused the misdemeanor.
I can even describe it to you.
He came early. He refused for the PM, for the bond hearing. Refused court. We said for tomorrow, Judge.
Then refused.
Carlos Fajardo.
Yeah.
Yes.
He's here, Judge. He'll need the interpreter.
Interpreter present.
He's got 2
Can
cases.
you hear me?
Just speak as loud as you can.
Can you hear me, Counsel?
It's faint. Just try your best.
We had him.
Very faint.
All right. So you're charged with, you got 2 cases. The first case, it's the 191 case. You had stalking, aggravated stalking, and domestic violence, which is what we did this morning probably. And on
Hay 2 casos. En la mañana
One-
se hizo el de violencia doméstica y ahora hay uno de acecho con agravantes.
in 192, it's you'll have another count of aggravated stalking again. And the misdemeanor we did this, and the domestic violence we did this morning.
What's
you
the
have
other count, Your Honor?
I'm sorry?
The second count that you said?
It's a domestic violence, which we did this morning.
Yes, I already told him that. I thought you said something else.
What's the standard bond on the?
Judge, I have PC arguments.
Okay.
Stalking can only be charged as an aggravated stalking, a felony, if involved in the stalking are credible threats. There's no such allegations in either A form. These are first-degree misdemeanors at most.
Su abogado está pidiendo una reducción de esta acusación de acecho.
Your Honor, for the aggravated stalking also can be for when a person has a injunction issued against them. And in this case, in the second paragraph of the A form, it mentioned that the victim had an active injunction against the defendant.
Según la fiscal, el acecho puede ser también cuando hay ya puesto una orden de alejamiento de la persona.
Mr. PD, so what's it? All right, let's talk avocados. What's the standard bond? On each count.
For the stolen aggravated is NF3, so it's 2,500. And the M1 is going to be 5,500. The one ending in 192 has NF3, that is also 2,500, and also misdemeanor 1,500.
Did we do the misdemeanors this morning?
I'm sorry, Your Honor?
Did we not do?
No, Your Honor, because these ones are attached to the felonies. The one that you, the Honor did on the misdemeanor is the FM 25-22791. But when they're attached to the felony, they come up in the felony case.
All right, standard bond counts.
Your Honor will be asking for also a house arrest, a GPS, if he posts the bond.
Judge, the case in 791 was a DV case. You gave her $1,000 bond earlier this morning.
So we said, can you repeat that correction?
The case incidents not 791, the bond was 1,000. You gave her this morning on a DV case.
Well, I thought.
Yes.
So that was what he said. So it's got 1,000.
Esta mañana cuando usted vino a violencia doméstica, le impusieron $1,000 de fianza. La fiscal está pidiendo también un arresto domiciliario aparte de las fianzas y un GPS.
So count 2 of 9-1 is 1,000, but count 2 of 9-2 is 500. Is that correct?
Did I issue stay wills? Yeah. Already.
Your Honor, but because there are two different case numbers, that's why you have the.
So you also stay away from Mabel Gonzalez and
It's
Tuca.
the same victim, Your Honor,
Same
different case numbers.
Twice. All right.
Tiene que mantenerse alejado de la señora Mabel González.
No drugs, no criminal activity, no possession of firearms, and you stay away from her at least 500 feet.
No puede poseer armas de fuego, no puede estar envuelto en delitos, ni tener drogas ilegales.
No. But before you move on, Judge, we did not follow through here. We're having a hard time hearing what the bonds on each count are and whether you issued yes.
I have GPS.
You did not do GPS.
No, I didn't. I got count 1, 2,500 on each case.
Okay.
191, he already has a $1,000 bond for the misdemeanor.
Okay.
On count on 192 is $2,500 for count 1 and $500 for count 2.
Okay, thank you.
No GPS, Your Honor?
No.
Mm-hmm. You have to come up with $650.
Okay, ya me felicitar.
Jaramillo. So you're charged with aggravated assault with a deadly weapon.
Say that again.
Good afternoon, Your Honor.
Judge, we have a bond.
That again?
We have argument for bond, Judge, or request for bond.
I don't know what state is seeking. This is it's aggravated assault with deadly weapon.
What the defense counsel say, Your Honor?
He has a he's waiting for you to.
What is state asking for bond?
I don't know.
500,000. Thank you so much. Thank you so much.
All right, now you have to go. Who's coming up?
What was the bond
I haven't set one yet.
amount?
Is it 5,000 or 500,000?
5,000.
So that's not.
Yes, Your Honor, all of them are battery, resisting of without violence,
So what do you-
but he has never been convicted.
Is that a statement bond?
Yes.
Statement bond is 5,000. Stay away. Stay away from Luis Jaramillo. You're not to engage in criminal activity or possess illegal drugs, and purchase or possess firearms or any types of weapons.
Okay. Este hombre, yo trabajaba con él
Febles.
desde que yo empecé. Él empezó en el 2006. Rodríguez, ese que yo te digo que Leo me llevó y me dijo, "You're gonna graduate with him." Cuando yo lo vi aquí.
Madam Interpreter, be muted.
Yes, Your Honor.
Lloyd Febles. Is he here?
He's here,
Hello?
Judge.
Yes.
Right.
You are, sir, you're charged with a litter law.
Litter law. ¿Qué, señor? Se le acusa por botar basura y violar la estatuto.
What kind of litter law if you violate? The dumpster? Because
Also, yeah.
if you throw a piece of paper out,
El señor juez quiere saber cuál fue la violación.
no, I'm not asking him, I'm asking Steve.
Yes,
Yeah,
Your Honor, he
okay.
was dumping tires.
Good.
He also has, he's out on felony bond, so we will be asking for a felony hold.
Judge, if I can.
Él-
Yes,
He's already been held. This is an added charge.
this is not a charge.
Esta es otra acusación porque ya te estaba bajo una fianza de delito mayor.
$1 bond, the felony.
Voy a poner $1 de fianza.
There's no PC, but I know.
It's not going anywhere,
Okay.
regardless.
Y no hay
Understood.
motivo fundado para esta causa.
Larry Wright. Are you, sir? So Mr. Wright?
Not.
So you're charged with cocaine possession, tampering with physical evidence, weapon possession while committing an offense, and
PC argument from the judge.
right?
So count one is upcharge is an F2. The statute does not contemplate a firearm upcharge. So that is that's an F3 at most. As to count two, it describes it as an attempt. If there is PC for an attempted tampering, then it's at most an M1, but I don't see any allegation in the A form that he was attempting to hide the bag. He went in with the bag. The officer sees him leave without the bag. There's no allegation that he discarded the bag because he saw the officer. He came in with the bag, he left without the bag. That's it. As to count four, charged with petty theft, he was being investigated, it seems, for shoplifting, but there's no allegation that he took anything. What he was scoping out, there's no allegation that he moved past the point of sale. So just to sum up, I think count one is at most an F3. I think there's no probable cause for count two, but at most an M1, and no probable cause for count four.
One second, Your Honor. Regarding the M2, the state doesn't have any PC arguments.
No PC.
On count four,
Four.
the M2 of petty theft.
Okay.
In count two. One second, Your Honor.
No count. PC four. Four, yeah.
One second.
that the defendant walked in with the bat and did not have it at the end, it's implied that he did something with the bat that's not have.
Bad or a bag?
So it's a bag, and implications aren't enough for PC.
Well, it's not really, okay, let me restate what I stated. It's not an implication. It's a logical inference given what is stated in the arrest. He walked in with the bat, he walked out without it. He no longer had the bat. He hid the bat. He did something with the bat. Person doesn't just get rid of an item that was in their possession and now no longer has it. But judge, if you're not find PC, then we would be asking to reset the PC argument for tomorrow.
That's a waste of time.
No kidding.
The mens rea element has to be specifically alleged for PC.
He's right. No PC. On count two.
It's count two, Judge. And then we still have count one to deal with. It's improperly charged as an F2. There's no contemplation of firearm of charges in count under that statute.
What's the PC argument? Can you repeat, please?
It seems to have upcharged him because of a firearm, but I didn't see one. I don't see any. I don't see anything in the statute that says that there's an upcharge for firearms.
That he was what?
I don't see anything in the statute that permits an upcharge on simple possession for concurrent possession of the firearm, and so I don't know how it's charged as an F2.
Cocaine? Okay. I don't understand the PC argument, but judge, just in terms of the statute, the defendant did have a loaded silver semi-automatic handgun in his hand, while he also had suspect crack cocaine in their bag. That's what these.
What he's saying is that the statute doesn't contemplate an enhancement because he's carrying a firearm. That's what he means. Instead of what F3, possession of cocaine, to F2, the enhancement.
Thank you, Judge. Currently charged as an F2, and if we look under subsection 1 of the Florida statute 893.13, if there subsection 1, a controlled substance is being carried, it is charged as an F2, judge, while in possession of a firearm.
Does it say that?
I just control searched the statute for firearm, for gun, for weapon. I don't see it. Judge, I can assist here. There is no firearm enhancement, but I do see that cocaine under that subsection is listed under 2A. So I'm sorry, it is an F2, just not for a firearm enhancement, but just for the substance.
Then Your Honor will be asking for you to find a PC for F2.
That's what I'm calling. Count 1, count 3.
Requesting
Count 2, no PC, count 4, no PC. What's the standard bond?
1 second. F2, Your Honor, is going to be
Corrections. What's it?
500, yeah. 1,000. Thank you.
Judge, given that Mr. Wright hasn't been in trouble in over 10 years, he has a stable address, he lives with his mom, would you be open to PTS alt bond?
Yeah, that's, your request is denied. Count 3, what's the standard bond? Count 3.
It's 2,500.
2,500.
So it's 5,000 count 1 and 2,500
count 3.
Okay.
I'm sorry, yeah, it's count 5. Standard bond as well. And PC.
500. So it's 5,000, 2,500, 500?
Yeah.
Okay.
5,000, release outright, 500, 2,500, release outright, and then 500.
Got it, thank you.
Mark Friedman.
Your Honor, the victims for this case are on the platform and they want to be here.
Is he here?
He's making his way out, Judge.
Okay.
A little slow moving right now. Hi.
Don't wait.
Thank you.
Mr. Friedman, you're charged with battery on a person over 65 and a misdemeanor battery. That's felony, then a misdemeanor battery.
And Judge, just before you read that A form, I would just point out on the first page, it says, it refers to victim child. Her name is Child. It's not a child victim. Just want to point that out. And I do have a PCR now.
But that's the mute.
Oh, no, he's, the judge is.
Mute is for us.
Okay.
All right. What's your argument?
I don't know, just stay as attended.
What's your argument?
I'm sorry, Judge, you were asking.
What's your argument?
Yes, Judge. So in the four corners of the A form, there's no confirmation of ages. There's a conclusory statement that he's being charged with the battery on someone over the age of 65. But there's no allegation that any of the victims were over the age of 65 in the four corners of the A form. So we're asking for probable cause as to M1 battery only.
Your Honor, in our copy, it appeared that, let me see. Your Honor, I don't know if the defense counsel has this last page of the arrest form, but it says in the victim, later on mention the victim, and it says his date of birth is April 19, 1946.
Okay, thank you, counsel. Thank you.
Let's find problems. What's the standard bond?
Your Honor, first, the victim wants to be heard.
Okay. Then where's the victim?
The victim is in the platform.
Okay.
Her name is Robin Child. If you're here, please unmute.
What?
No, you're okay. They're asking your sister.
That's fine. Oh, let me see what she said.
Ma'am, go ahead.
Try to kill himself. Why? Stop it.
I don't think he could have just said he's suicidal, because when I wasn't suicidal, but I was afraid of getting raped someone, so I said I was, and I had my own cell. And then of course I had to stay the weekend.
You're a kid.
Ma'am, if you can please speak louder so we can hear you.
Miss Child, please speak up.
Hello?
Yes, we're waiting for you.
Okay.
Can you hear us?
Yes, we can.
Okay.
Okay. That's my brother, and I love him, and I want him to be well. And I don't want him to go to jail. I just want him to go to some kind of classes, because he was out of control. And I love him, and I don't want him to be sick. But he can't go on punishing me for things that I don't have anything to do with. I try to help him every day of my life. I gave up all my 8 years to service him and give him his medicine and make sure he went to the doctor and everything else. And he just lost it. He just lost it. He needs to go into some kind of a facility or get some kind of help, so that he gets anger management. And that's what I think. He's not a bad person. He's a good man, and he has to get help. That's all I have to say. I'm sorry that this happened, and I'm so sick. You can't imagine how I feel, because he's the only thing I have left, and I don't want him to be that way.
When spoke to her this morning, she indicated that she was scared that if the defendant got released, he's going to end up killing her. And that there is a pattern of domestic violence, and the same thing with victim number 2, who explained that he has been living close to their house for 8 years, and the defendant has been incarnating in a DV pattern for 8 years. We will be asking for if he's going to be released for house arrest with GPS level 1, he has to go and reside in another place that is not the victim's house.
And Judge, I would only ask if you could ask the alleged victims in this case if they're amenable to a stay away order that is a no harmful contact stay away order. And the reason that would be necessary is because he's not going to be able to bond himself out. He doesn't have access to his cards. He's got nobody else to call in order to bond him out.
Are you asking for monetary bond or just house arrest?
We're asking
I'll call you back. Let me call you back.
That's it. All right. Right. What's the standard?
Count 1,2,500, count 2,000.
All right.
Judge, he has some money here, but he has to go for help. He needs to go for help for anger management.
It'll be house arrest with GPS, number 1.
So Judge, we're requesting just the standard bond because he may not have a house to go to if these are the folks that he's living with. And so we're asking for standard bond and a no harmful contact order.
That's not my rule. House arrest GPS, alternate bond on count 1, 2,500.
And count 2, 1,000.
And count 2, 1,000.
There is a stay away order, just one moment.
2 stay away.
Yes, 2 stay away orders. Are you ordering the defendant to not stay in that house, Judge?
I am ordering not to stay in that house.
Thank you.
So you just stay away from Robin Child and Martin Rosen. Not to contact with them. You're not to engage in criminal activity like drugs, possess firearms, or weapons on both of those individuals.
Cousins, you need to see if they can home.
Your Honor, we can recall when the court.
No, I'm gonna finish my comment. Then I'll
Leave a note that somebody's gonna have to get in touch with you today in order to help you out with this, okay? Just hang tight, all right? Oh.
Isaac, Eric Isaac.
Okay, Judge, we're gonna need a moment to
That again?
we're gonna need a moment to get Mr. Freeman out.
I understand.
Oh, he's in a walker.
All right. Eric Isaac Montoya.
I don't have him yet. He's gonna need the service of the interpreter.
He's out of felony warrant, Judge, F25-663 Alpha.
Nice.
Judge, and in this case.
Interpreter present.
We're asking that in these cases, he be held no bond. We have 1, 2, 3, 4, 5, 6 cases before you, to stay aware for all of them. Many times.
I've got one over here.
I'm giving you the. This part.
All right. The charge of the book criminals.
So Judge,
One. I'm sorry. All right. No.
Judge, I couldn't quite hear the prosecutor what she said about holding Mr. Favon no bond.
Because he has about 7 cases and another open felony, and he's being held on that felony. Nonetheless, we're asking for him to be held no bond in all of these cases.
Can't do that. You can hold him for the felony hold, Judge, if he's got an open felony, if he's out on bond, but you can't hold him no bond on these counts.
Why can't he hold him?
Yeah, that's not for you to argue with. I'm the one that should decide.
Yes, sir.
All right. Yeah, I just want to make sure we got all these cases. We have case ending in 206, case ending in 189, case ending in 188, case ending in 187, case ending in 183, and case ending in 183, and case ending in 115. Correct? So let me look at the counts. We got case 189, we have 3 counts: burglary, grand theft, and criminal mischief. And case 188, we have 2 counts: burglary and grand theft. In case 187, we have 8 counts. 1 count of burglary on an unoccupied structure, 5 counts of burglary on an occupied conveyance, 1 count of criminal mischief, and 1 count of petty theft. In case In 183, we have 4 counts. Count 1, heroin possession. Count 2, cocaine possession. Count 3, burglary possession. Count 4, drug possession of drug paraphernalia. In case 182, we have 3 counts: burglary of an occupied dwelling or structure, petty theft, and criminal mischief. In case 181, we have 2 counts: burglary of an occupied conveyance and grand theft. Am I correct?
That's right, Judge.
Well,
Señor, hay una lista de casos acá con varios
It's a
cargos.
state fugitive, Judge. I just wanted to let you know
the future, what?
that he is a state fugitive in another case. They're looking for him. We don't know what state, but I have your number.
I got you. This time I find that there's nothing I can put together as a condition of release that will keep the community safe. Therefore, there's no bond.
That's unconstitutional.
Then take me out.
Ok, señor, debido a la cantidad de
No legal
casos,
authority to do that.
I got 7
cantidad de
7 to
casos
stay
y
away
de
from
cargos,
Northeast 79th Street.
no
Apartment
hay fianza.
302.
Judge, each case, each count, no vote?
On each count.
Not
In each case, I'm sorry.
Not only is it
Like a felony count.
not only is it not constitutional, it's not necessary because he's held on an open felony.
And he's got a felony. Like I said, you can pick me up, Councilman.
Según su abogado, esto es, no es
633,
constitucional y
633 Northeast
requiere
79th
otra
Street,
vía, pero el juez ha dicho que no va a dar fianza.
Apartment 302. You're to stay away from 100 Northeast 12th Avenue, Miami, Florida. You're to stay away from 36 Northwest 79th Street. You're to stay away from 21 Northeast 2nd Avenue. And there's one more.
Está citando las localidades donde
You're to
usted
stay away from
ocurrió los
760
allanamientos.
Northeast 25th Street. Let me sign. Have a good day, sir.
Tenga buen día, señor.
Thanks.
Yeah, I can hear you say, but I can hear you.
Ujú.
Yeah, I'm looking that one.
Espera.
Jethro Allard here. So you're charged with two counts of battery on police officer or firefighter. Want to find probable cause? What's the standard bottom of each count?
Yes, 2,500. Yeah.
$2,500 each count. Okay. Let's do the PC. Who's the police officer?
Deputy Gonzalez, can you please, unmute, and the judge would like to see you on video.
Yes, just 1 second.
Deputy Whipple, Carlton Whipple.
Good afternoon. How you
Deputy
doing?
Gonzalez, can you? We need Deputy Gonzalez, not Officer Gonzalez. Thank you, though, officer.
So he's not here?
No, he's here. Deputy Gonzalez, please, take your camera off so the judge can see you. Thank you so much. All right, he's there, Judge. I don't know if you can see him.
I see him.
Thank you. Deputy Gonzalez, you're gonna have to speak really loud, almost screaming, because our Zoom system is not working very well. We're on the case of Whipple Carlton. This case was reset for PC hearing on the count of cocaine delivery of near public housing or within 1,000 feet of public housing. The question, Deputy, is how far was this defendant from the public housing?
Less than 1,000 feet.
I could have said that.
Okay, and how do you know that? Because we're trying to establish this from the arrest form.
It's right towards the end of the street. And then the other side of the street on the north side is the public housing Circle Plaza.
Okay, Circle Plaza, do you have the address for Circle Plaza so we can ask the judge to take judicial notice?
It should be 102 Avenue and Fern Street.
102 Avenue?
And Fern Street.
You hear? Fern Street?
Yes, FERN.
Thank you. Okay. 102 Avenue and Fern Street?
Firm.
Yes.
ERM. Like a Mary.
No, N. N as an answer.
N as an answer.
Foxtrot Echo Romeo November.
So that's 102 Avenue and Fern Street, Miami, Florida. What's the zip code?
Not sure. I could look up for you.
Would it be 33157?
Should be. It's in Perrine.
It's in what?
Perrine.
The Ryan does. I think it's not big.
Okay, is that in Miami-Dade County?
Yes, it's Miami-Dade County.
Okay, yes. So Judge, given the officer's representations, he did state in the arrest form that it was just north of Circle Plaza. And the officer's representation that it is less than 1,000 feet. He has provided us with the address. And based on the address that's on the arrest form where the defendant was arrested, it's 104th Avenue. And the address of Circle Plaza, which is public housing, is 102 Avenue. So it's only 2 avenues away. We would be asking you to take notice of that and find probable cause for the first charge, which is cocaine delivery within 1,000 feet of a school, a public housing, excuse.
I thought I had fixed the A form. I had put the wrong address on the A form. It should be 102 Avenue and 174.
Okay. So
it's now 104 Avenue.
So the arrest form should say 102, Judge. It says 104. The officer stating that that was a typo on his end.
Does anyone say this to the public defender?
Judge, I haven't heard anything establishing how we know it's less than 1,000 feet. And taking notice of facts that are not alleged in the A form after the fact is not how you establish probable cause within the 4 corners of the A form. What within the 4 corners of the A form establishes that it's less than 1,000 feet? It could be next door and not be less than 1,000 feet. There's nothing to establish that it's within that zone.
Judge,
I can give you an exact arrest location because the mobile home is connected to the next to the residence.
And the arrest form, it does say, let it be known that just north of the arrest location on Fern Street, it's a public housing community. And what the officer just stated is that the address listed on the arrest form was a typo. It should be 102, not 104. So it's on the same street.
Judge, I would just say that public housing could be on the same street. It could be just north. It could be one address number away. And we don't know that it is within 1,000 feet of the public housing.
1,000 feet is a block. A regular block. It's 1,000.
And I think I just heard the prosecutor argue that this address is 2 blocks away.
That was before the officer corrected me, stating that the address that's listed on the arrest form is incorrect. He meant to write 102 instead of 104.
So the address in the 4 corners of the A form is incorrect.
No, but that's what it's here.
Yeah.
So I'm gonna find out.
Thank you. And Judge, we do have a pretrial detention motion for this case.
Doesn't qualify, Judge.
I don't know what it is.
Oh, Hannah.
What was the bond amount?
We don't know that yet. Tell them what it qualifies so they can start looking at it.
Excuse me, Judge?
Tell them why it doesn't qualify so they can start looking at it.
Okay. A crime being in F1 does not mean it qualifies for pretrial detention. It has to be designated as a dangerous crime. There is a subsection that lists out those dangerous crimes.
I think there's a subsection as well.
Subsection 5.
With narcotics.
Yeah. Sorry, Judge?
There's also a subsection that talks about narcotics.
The only subsection that talks about narcotics is number 24, trafficking in controlled substance described under 893.1351C4, which is fentanyl and all its and all the variations of fentanyl.
Okay, that's what I wanted to. That's what I wanted to say.
Yes, Judge. I can't hear you.
They're working on it.
Sorry.
You got 11, 20, 23 grams of cocaine total. That's less than 20.
I'm sorry, what are you saying? Judge, what did you say about 23 grams? I don't see that all.
I look at the counts. I just stated what the counts said. Like 12 grams, one count, 7 grams, another count, and 4 grams, another count.
So the cocaine, Judge, I only see plus or minus 1 gram and then plus or minus 2 grams, page 2.
Okay.
So
what is the statute say?
We can't hear.
That was 28 grams or more, but these are not 28 grams.
No, Judge. It proceeds to state or more cocaine or any mixture containing cocaine, but less than 100 kilograms.
So it's alleged not more than 4 grams of the cocaine. I don't know if now we're arguing about whether it's an F1 or it's another degree felony. Doesn't change the fact that it doesn't qualify for pretrial detention.
Okay, Judge.
You got 5 minutes
Yes, Judge.
or less.
Judge, okay, under Florida statute, which is 893.0356, it states any new controlled analog substance. So analog substances as defined by the statute are those which have a potential for abuse similar or greater to or greater than that for substances controlled under this chapter. So counsel is correct in that cocaine itself is not listed under the listed substances. However, when we look at this statute, which is also included there, we would argue to your honor that it is a analog substance because it's crack cocaine. It's not just cocaine, it's crack cocaine. And so we would argue that there's a potential for abuse given that.
Pleasure for abuse, every substance that's illegal.
It's an analog substance and then it's a new substance.
Mr. PD?
Judge, I don't know what statutory language they're reading. I'm going to go to 893.1351C4, which is the only narcotics offense that qualifies for pretrial detention and trafficking and such, not intent with possession to sell. But under that, so that's another question that we have to answer. There's no allegation of trafficking.
All right, why don't we shortcut this?
Yeah.
He's not eligible for pretrial detention.
Okay, and just to answer counsel's question, it was C4, but it was subsection
And
6.
I have the previous judge said something about the bond itself. They said the judge mentioned one yesterday.
Yesterday, Judge, they found PC, but they did not mention bond.
All right.
They issued a fugitive hold.
Okay. So
there is a fugitive hold?
There's a fugitive hold.
Okay.
Okay, well, count one. What's the standard bond?
You have a few.
It's what, 75? 75 on count one, count two.
And just because he does have a fugitive hold, we would be asking for GPS monitor.
It's not a fugitive like he's running away fugitive hold. He got out of prison, and so it's just for conditional release review.
I just want to know what count two standard bonds. Right
Yeah.
now. Is that 5,000? Count two, bond 5,000. How about count two? 75? $7,500 on count three. And count four. And count four is also $7,500.
I'm sorry, what's count four?
75. So it's got 75, 5, 75, and 75.
Count 5.
Yeah, count 5 is it's an F3, so what is it? 25 count 5. So if he has speech of hold, what does that mean?
It means that if
It's
you were
already
to
been
bond out,
held, sir. It's an F4.
He's already been held?
Yes, it's not a fugitive hold. It's an F4 hold. No
So-
bond. He already been held, no bond in that case.
Okay, I'm sorry. That means he cannot go anywhere with a hold.
That's
correct?
correct. He's been
Okay,
held.
so he's got a fugitive hold, he's not going anywhere. But the bond stands. Do I see you tomorrow again, or somebody else is going to take the? Oh, how about the PD?
sorry, Judge?
Will you move more?
No, sir.
Good for you. How about the state? No, even better. Okay. Have a wonderful week. Yeah,
We need to go upstairs. Yeah.
that's what I said. You got 5 minutes. We might stamp, so you know we might stamp. There you go. Got more to the tickets. Good. Three my class.
Madam Clerk.
I thought you were a foul.
Madam Clerk.
How you guys doing? Am I good to go?
All right, let me try my. Give me 1 second, Joe.
Okay, we're done. I guess we're done.
We're done? All right.
Here, every freaking weekend. Yeah. But no, I understand that.
Yeah, she does, and I'm like,
But for me, I understand that.
I do the same.
I understand completely because my uncle, he's only probably English.
Recording stopped.
No, they throw it. And they. Like how he did it. Right. Yes. So the argument should be what you should do is ask people who know how to in then set a standard of elevating. Then he has to pay new bonds. Right. And it is one of the qualified. But it is. There again, it is considered a dangerous area. As long as it's an F1, but if you want, you could technically argue anything you want. Yeah, I just want to make sure it's like that. When it's an F1, it is a. But those burglaries. I'm looking for the highest tag was highest tag was not true. That's the other thing. You get a mess. Cocaine never, even cocaine trafficking, not following. Completely armed in trafficking. You've seen so many times. There was last time. He's right. Or unfortunately. If the judge obviously but that's too broad of a definition, and that's why it's never really used. It's not really used, but we have to. You get me like you could. For example, maybe he would have. And that Tusi is another one that yeah, because that doesn't follow the category. Why not? That's what I'm saying. So that's what we should argue. State of Florida has its rules, and we don't. I want to put there. No problem. Yeah, I'm gonna finish down here. I don't have very much left.
It's old now.
We took too long at Publix.
Yeah.
We were at Publix. Oh, we got 3 left. Ran over here. You guys are good guys. And I feel out of place on you guys. I didn't go to law school. But at the same, as I said, I feel out of place in anything. I went to law school.
But it's good for you to tell us. Obviously, like, sometimes we don't have enough. Like, I'm trying to argue to them.